Morning, I'm Beverly Bowles, the Head of Cyber with ScotlandIS. For those of you who don't know about ScotlandIS, we're the trade body and cluster management organisation for the digital tech sector in Scotland. Just over a year ago, we launched our Tech Tidbit series, which take place on the first Tuesday of every month. These sessions last for 30 minutes and are designed to educate you on areas that you may want to know more about, encourage you to innovate with your newfound knowledge, and potentially collaborate with the hosts of the presentations. Today's session will be followed by a Q&A and an opportunity to ask the questions, and I would ask that you place them in the chat box. Today, we are focusing on legal privilege when it comes to cyber incidents, why it matters, the different forms, how to preserve it under pressure, and the common ways it gets waived. Please allow me to welcome Nick Warlow from long-standing ScotlandIS member Burness Paull. And Nick, I'll hand over to you now. Thank you.
Thanks, Bev. Good morning, everyone, and thanks for joining this session. As Bev says, my name's Nick Warlow. I'm joined by my colleague Louise, and we both come from Burness Paull, and we work in our disputes team, and in particular we focus on regulatory investigations and as a subset of that, dealing with a lot of cyber-related incidents and cyber investigations. So we're going to talk to you today, give you a brief overview of legal privilege and how it crops up as an issue when managing cyber incidents, with some tips on how to manage it and how best to take actions to preserve documents which are subject to legal privilege. Louise is in control of the slides, so I'm going to rely on her to move us along. So just as an introductory piece, it's just a brief introduction on how privilege is relevant. So when we're talking about cyber incidents, we're talking about the work we do in terms of managing the fallout after an incident's occurred. So a company which is subject to a cyber attack obviously has to deal with the technological aspects of that attack. But linked to that, there may well be a follow-on regulatory investigation led by the Information Commission's Office, the ICO. And again, following on from that, there may be some form of legal claims or litigation. And the concept of legal privilege is relevant to both any regulatory investigation or any litigation that ensues from a cyber incident. And the risk is that if a document is not privileged, not subject to legal privilege, then that document may have to be disclosed either to a regulator or to a claimant, and therefore made public. So it's important to make sure that where possible, sensitive documents, confidential documents are preserved so that they don't have to be disclosed into the public domain in an investigation or a litigation. So we're just going to start off by giving a quick overview of the different forms of privilege. Now, there are lots of privilege forms in which it can take. The two key forms that we're going to just cover today are legal advice privilege and litigation privilege, because they're the most relevant to the issues in dealing with a cyber incident. Legal advice privilege first. So this protects a communication between a lawyer and their client, and that's the only circumstance in which it exists, and it specifically relates to where that document contains legal advice, so either where legal advice is being sought from the lawyer or being given by the lawyer to the client. And it's important that the privilege only attaches to the content of those communications which concern the giving or obtaining of legal advice. So if the communications broach other subjects which are commercial or strategic, then privilege won't attach to those parts of the communication. It is specifically relevant only to the sections of the communications that relate to where legal advice is being given or sought. By contrast, litigation privilege is a bit broader. It can apply in different circumstances. So the key aspect of litigation privilege is that it can only exist at a certain point of time and only from that point onwards. And that point of time is when a litigation exists, is pending, or is reasonably contemplated. So up until the point at which litigation privilege kicks in, it doesn't exist prior to that point in time. So there's quite a lot of argument and debate and case law about at what point a litigation is deemed to be pending or reasonably contemplated, and it will ultimately always depend on the circumstances. At that point onwards, then a document that is created specifically for the dominant purpose of litigation can be covered by litigation privilege, as long as it is between a lawyer and the client, or between either the lawyer and the client and a third party. So if we're thinking about a cyber incident and managing it, it could relate, for example, to a report which is produced by a third party for the benefit of the client or the company, or instructed by relation to, for example, the IT or forensic aspects of a cyber investigation. So the litigation privilege will only apply to that document if the incident has reached a point of time in which litigation is pending or reasonably contemplated at that point onwards, and any document created for the dominant purpose of litigation from then on can be covered by litigation privilege. Louise is going to just discuss contractual confidentiality.
So contractual confidentiality is slightly different from privilege, but it is the starting point for all communications between solicitors and their clients in Scotland are presumed to have a confidential nature, particularly if it is information the client passes to the solicitor for the purposes of instruction. And anything in the course of that communication has a presumed quality of confidence that means it ought not to be disclosed. However, there are some circumstances where information like that may be disclosed in a court process, i.e. in litigation. So unlike the two types of privilege that Nick has described that have more scrutiny in the courts, the starting point in Scotland is confidentiality, but generally is superseded by privilege. So if you want to protect documents from being disclosed, either litigation privilege or legal advice privilege is the most comprehensive way of doing that. I'll talk a bit about how privilege applies in cyber incidents now. So any documents that are created or relate to a cyber incident will not automatically be privileged. In the aftermath of any cyber incident, our experience is there's quite a lot of documentation created really quite quickly. That ranges from emails from the cyber teams, from senior decision makers, communications with staff, and so on. All of those documents may become relevant at a later stage, as Nick referred to earlier, whether it's litigation or an investigation by a regulator. Those documents won't automatically attract privilege unless it falls within one of the categories that Nick's described. So it will depend on the facts and circumstances. Litigation privilege is very unlikely to apply if it's a purely internal investigation, or it's in response to the very early stages of a regulatory investigation. So the very early stages, for example, of the ICO looking into an incident. It's only where there's that real likelihood of adversarial proceedings that litigation privilege may start to apply to documents that are created in relation to the incident. What can be helpful at that stage is to have something on record that shows you've considered when litigation may be contemplated following a cyber incident. That might be a customer, a supplier, somebody threatening legal action. In terms of legal advice privilege, it comes back to the question Nick flagged. The documents relating to the incident will only attract that privilege if they contain legal advice. If not, and if there's no reasonable contemplation of a regulatory investigation or court proceedings, then any documents created won't attract privilege.
Thanks, Louise. So the question is, if a document isn't covered by legal privilege, then what happens to it? So if you have a sensitive or commercial or confidential document, that has been created as a result of or during the course of the cyber incident, if it's not privileged, then it is open to be disclosed to a regulator or to a claimant in litigation. Now, just because they request it doesn't mean you have to hand it over. It has to be relevant, and they have to be able to justify the relevance of that document to either their investigation or the claim if it's being sought by a claimant in litigation. But so long as it is relevant and you can't dispute that, and it's not covered by legal privilege, then that document will need to be disclosed to the regulator or to the claimant. And in particular, in relation to court proceedings, if you're disclosing it to the claimant, then you're effectively handing it over in open court, and it enters the public domain at that point. So that's why if a document contains materials which is sensitive or confidential and you don't want it to be publicly available, it's important to try and maintain a claim of privilege over it if the circumstances apply, in which case you wouldn't have to hand it over. But as Louise said, just because a document is created during the course of a cyber incident doesn't mean that privilege would necessarily apply. It only applies if the circumstances are in place. If not, then it is ultimately a document which can be requested and can be disclosed to a regulator or to a claimant. That is why it's important to try and maintain privilege, or at least not waive privilege if it exists. So I'll hand over to Louise here and she'll talk you through some of the steps you can take to make sure that you maintain a claimed privilege where possible.
So the starting point is involving legal advisors immediately will allow you to will open up privilege because you'll be seeking and receiving legal advice, or it may be in contemplation of litigation. That having solicitors involved will help ensure that the advice and the investigations are framed within privilege where possible from the very earliest stage. As I said, internal investigations will not automatically be privileged unless it attracts legal advice or litigation preparation, and solicitors can help set up the instructions, the communications and the documentation so that it maintains that quality of privilege, so it doesn't need to be disclosed as in the ways Nick has described. Solicitors can instruct third-party experts on behalf of a client, and that will allow privilege to be asserted over the output of that report. That can be very, very important when you think about cyber incidents and there's a lot of factual information that's got to be established, and having privilege over it means it's not open to immediate disclosure to somebody seeking to investigate or to pursue a claim against you. So how to preserve privilege when it's been established. As I say, you can instruct experts through solicitors. Labelling communications is a very easy way to ensure that privilege is maintained. Having privileged in the subject line, having it mentioned somewhere in the body of the email, in the documents, as a header, strictly confidential and legally privileged. The people involved is very important. Thinking about who needs to be involved, who the decision makers are, and keeping that a small group. Separating off the legal advice from the commercial discussions makes it much easier to be able to assert privilege over a document if you're saying it should benefit from legal advice privilege. That's much more difficult if it's mixed in with commercial or strategic discussions. And helping your staff understand the importance of privilege will make it easier to maintain it in practice and ensuring it's not waived inadvertently, and to ensure that it's established at the very outset. Ways not to waive it, it's the converse of the slide we've just discussed. Keeping the distribution list small, not to be sharing legal advice or privileged documents beyond the legal team or beyond a small number of decision makers that need to know. That also extends to thinking about third parties. Sending privileged advice or information outside of the organisation may mean that privilege has been waived and you'll no longer be able to assert privilege, and it can therefore be disclosed. Keeping the legal and the commercial separate, and maintaining a really clear documentation of when solicitors were instructed, when reports were instructed and why, what communications were issued and on what basis, so that you're able to look back and identify confidential documents. It's something we see that is very important at the outset when you're in the heat of the moment and dealing with an incident. It may not be the first thing organisations think of, but it can become important very quickly. And then we also see it further down the line when litigations might be going ahead, maybe 2 or 3 years after the incident, being able to look back and see those clear records, see documents that are labelled privilege, and therefore be able to assert privilege on behalf of our clients and be able to resist disclosure.
Thanks, Liz. I think it's important just to note as well that none of these steps in themselves guarantee that a document will be privileged or that privilege applies to them. Just putting a label on a document itself doesn't mean that the document's privileged. Equally, none of the steps on their own will ultimately be decisive as to whether the document's privileged or not. You have to have all the relevant criteria in place. So the document has to be clearly obtaining or receiving legal advice to constitute legal advice privilege. Doesn't matter how you treat the document, what you label it, how it's maintained internally. The content itself has to fit the criteria for legal advice privilege and similarly for litigation privilege as well. So the advice that we're giving here in terms of steps to take and not to take are all steps to help an argument that a document may be privileged, but it is a very contested area, and often you end up with quite substantial disputes as to whether documents or a set of documents are or are not privileged, and it will all depend on the circumstances, and that will include what the content of the document is and how that document has been treated. So these are all steps that we would say are advisory steps that you should take, but taking them on their own doesn't guarantee that privilege will apply. So just in summary, in terms of do's and don'ts, do involve lawyers at the outset, because then you can have advice on what documents may or not be privileged and what steps you can take to ensure that privilege will apply if it is applicable. To the extent that documents may be privileged, then ensure they are marked in that way, and where possible instruct third-party experts through solicitors, again, to increase the likelihood that privilege will apply to the relevant documents. As we said, maintain clear records and ensure that your team internally understands the concept of privilege and what steps to take to make sure that any relevant documents are treated appropriately. And don't assume that privilege applies automatically to everything, because it won't. There are steps you can take to increase the chances that documents will be privileged and to maintain them as such. But be conscious of the fact that if privilege doesn't apply, then documents will be disclosable. So it's just a question of doing what you can to make sure that sensitive and commercial documents are protected to the extent possible. So don't share reports more widely than they need to be shared, and try and separate out legal advice, which should be subject to privilege, from wider commercial and strategic communications, to ensure that your pool of potentially privileged documents is as restricted as possible, and then it's easier to preserve that privilege to the extent that it exists. So I think that's the end of the slides, and we've got a few minutes for any questions. I think there is a question already in the chat, which I haven't had a chance to look at yet. So the question is from Stephen: I've seen some communications of potentially sensitive information written as without prejudice. How does this affect the status of the document? So that without prejudice privilege is another form of privilege. So not one that we've covered in this, because it doesn't directly relate to cyber incidents, but without prejudice privilege relates to communications between parties with a view to trying to settle matter. So it's effectively creates a confidential channel of communication between parties to enable them to try and settle a dispute, and those communications will not be disclosable to court unless it's a question of costs. So by labeling something without prejudice, you can only do that if it's a genuine attempt to settle a dispute. Just by putting a label on something, much as the same of just because you can't just label something as being legally privileged doesn't mean that it necessarily is. But as long as it's a genuine attempt to settle a dispute, then it can be subject to without prejudice privilege. Equally, labeling something as a legal advice privilege or litigation privilege won't necessarily make it privilege unless it fulfills all the criteria necessary for privilege to apply to that document.
Yeah, and I'd just add to that, Nick, in Scotland it is actually quite a narrow interpretation of without prejudice, and it really is only concessions for the purpose of settlement. And in Scotland it might be the case that a chain of correspondence, only certain parts of it would attract without prejudice privilege. So it is really quite narrow, although you do see it used far more than it would actually apply.
Exactly, and so labeling something in itself doesn't necessarily make a difference. It can always help if all the criteria are met for that document. I'm just seeing another question come through. If you had instructed experts through a solicitor and they had produced a report that's covered by legal advice privilege, would the raw data used to compile the report also be covered? Network logs or other technical information? So that's a really good question. The short answer is no. So this comes back to the point that I think Louise was covering earlier, that privilege attaches to the content of communications that is actually privileged. So to the extent you mix privileged material with other wider commercial or other material, then the privilege only attaches to the specific communications that are caught by the criteria. So whether that's legal advice or litigation privilege. So unless the data has been created itself for the purpose of the litigation, then it wouldn't necessarily be caught. So the data in this case, the subject of the question, would have to fulfill the criteria of legal advice privilege or litigation privilege for privilege to attach to it. So each separate document would have all the various criteria applied to it to determine whether or not they would be subject to privilege.
There's another question in the chat, Nick. If you're covered by cyber insurance and breach counsel is stood up when that is invoked, does that automatically start privilege?
If they're instructed, it depends on what we're dealing with. If there are a particular document or particular communications, so if counsel, whoever it is, if the lawyer is instructed and then you fulfill it, again, you go back to the question of, do you fulfill the criteria for legal advice privilege to apply? So is the communication or the document in question obtaining or receiving legal advice? So if it fulfills those criteria, then it would be covered by legal advice privilege. Just because a solicitor is instructed doesn't necessarily mean that any communications from that point onwards are covered by legal advice privilege. The communications in question would have to fulfill the criteria, which are, does that communication constitute legal advice being sought or obtained? I hope that answers the question.
Great. Yeah, we've got a thanks from that. I can see that Andrew is typing, but while he types his question, I just wanted to ask, so how should communications between technical teams, clients and external counsel be managed to ensure privileged information isn't exposed, e.g. through email chains or shared documents?
Louise, do you want to have a go at that one?
Yes. Sorry, I was sort of reading Andrew's question as it came in there. In order to maintain privilege, as Nick said, it's not just simply about marking things privilege, it really has to have that genuine nature of privilege. It has to be correspondence for the purposes of litigation where it's reasonable in contemplation, or for obtaining legal advice. So where there are channels of communications internally, simply between employees dealing with the aftermath of an incident, if it doesn't have that reasonable apprehension of litigation or regulatory investigation, then it's going to be difficult for that to attract legal privilege. If it is that a report or investigations are being undertaken in order to prepare, then if that's marked in the internal communications, that might be a way that privilege or confidentiality might be asserted.
Great. And is it possible to have privilege declared for future events, e.g. a cyber incident, to prevent delays in the response while privilege is being obtained?
I think that comes back possibly to the same point, that it has to have that inherent nature of privilege by way of falling into one of those categories that Nick had set out at the beginning. So it wouldn't be possible to say all our communications will be privileged. What you can do is have a cyber incident response plan that sets you up so that you do instruct solicitors that your communications do fall within the categories that would allow somebody to assert privilege. I don't know, Nick, if you have something else to add.
Yeah, I think that's right. It comes down to, every bit of correspondence or every document is judged on its own merits as to whether privilege applies to it. So you can't throw forward and say anything from now on is going to be privileged. Each communication or each document produced from that point onwards is assessed against the criteria as to whether privilege applies to them.
Great. And should you always invoke privilege before notifying the ICO of a notifiable breach?
No, you don't need to. It's a sort of separate issue. You notify the ICO of a breach, and then there may be then communications with the ICO, and to the extent that you have documents or they request documents you don't want to disclose on the basis of privilege, at that point you can assert privilege over those documents and explain the basis of that. You don't need to sort of pre-warn them that there may be a privileged documents in relation to those communications.
Right. And do you see privilege considerations changing as cyber incidents increasingly involve multiple vendors, cloud providers, and international jurisdictions?
That's a big question. I don't think it will change in the sense that the principles will always apply. It will become more difficult. It becomes quite a complex task. The more parties are involved, the more documents are being produced to identify what is privileged and to maintain the privilege of those documents. That's why some of the points that Louise was covering earlier about being clear in terms of logging documents and keeping the distribution of certain documents as minimal as possible becomes more important. The more parties are involved and the more complex it gets, the greater the risk, I suppose, of waiving privilege, even by accident. Mm-hmm. So it then becomes more important to maintain, identify the documents which are the most sensitive or confidential to which privilege applies, and make sure that you're taking all steps necessary to preserve privilege over those documents when there are lots of different parties becoming involved in different jurisdictions.
Great, thanks, Nick. And just finally, should we set up processes or SOPs internally for handling cyber incidents and have those reviewed by a solicitor?
Go on, Louise.
Yes, we'll definitely say that is helpful. Having the processes in advance, having the incident response plan prepared that has issues like privilege and confidentiality and disclosure of documents in place in advance will make it much easier in that crisis point to ensure that you are setting yourself up, setting up your investigations and your communications in the best way possible so that you may be able to attract these protections. So having those in place will make it easier, and it's certainly something we do work with our clients on as their processes and how they should deal with incidents in advance.
That's great. So thanks very much, Nick and Louise, for that this morning. It was really interesting. And if anybody on the chat would like an introduction to either Nick or Louise, then please drop myself a note, and we'll make the introductions for you. And would we be able to make the slides available for people that have come onto the chat or maybe haven't been able to make it along this morning? That'd be great.
Yep.
Our next Tech Tidbit will be on the 4th of November, where Catherine Strachan from, so what organisation is she from, Catherine Strachan?
She's like
Who's a consultant, is going to tell us how we can turn ChatGPT into a business growth engine. So hopefully you'll be able to join us for that. But thanks again for this morning, Nick and Louise, and thanks to all of you for joining us, and hopefully see you again next month. Thanks a lot. Bye just now.
Thank you, everyone.